Let's talk about codicils today. So, in a situation where you have made a will, I know this is one conversation people don't always want to have, because when you mention preparation of wills to anybody, they just feel like you're telling them to prepare for their death. Well, that is not the case. You can actually use wills to plan your estate, to plan your properties, to plan legacy for your family. Yes, I said what I said. So when you have bequeathed properties to people who you think are entitled to your estate as your beneficiaries, and maybe it gets to a point as a testator, that's the person who has made that will, and you feel like, no, the relationship I had with this person when I was making this will is no longer there. The status has changed, or you have now acquired new property or properties that you want to incorporate into your will, or you want to remove something that you had earlier entered into your will that you don't see as necessary anymore. What are you going to do? Are you going to keep that same will there and then draw up a separate will to now contain your new instructions? There is something the law calls codicils. These are also legal documents. Yes, it's a separate document that can also contain those instructions, those changes that you want to effect in your current will. You can put those instructions there, sign as a testator, and that becomes a valid instrument under our law. This means that whoever you bequeath anything to under that codicil will automatically be entitled to it. And this also means that when the will is being read, the codicil will be read also. Okay, so it does not make any sense under the law for you to have two separate wills. Okay, so the codicil is like a single document with which you can make changes to your will. Whatever change that you want to make to your will, you can use that codicil to make such a change. Now, I have this situation where somebody has been called to draw up a will. After drawing up the will, the testator now requested for his attention to alter or make some changes. Now we have two separate wills, two separate documents inside a confidential envelope for a particular testator. Now one of the executors and some of the beneficiaries are actually contesting one of those documents because they feel that one of those documents do not actually express the intention of the testator. So these are problems that can actually emerge when we do not do the proper thing. This is Xavier Law Essence. Here we give you premium legal tips to help you make informed decision, live informed life, and discover the very best version of yourself. We'll see you again.